Justice Gorsuch? Justice Kavanaugh?
I'd like to get your views on pages 25 and 26 of the Solicitor General of the United States' brief, where they say this court should hold that the plaintiff's illustrative district cannot disregard the state's political objectives, and further say that Section 2 plaintiffs cannot claim a lack of equal openness where politics rather than race is the likely reason for the state's refusal to create a majority-minority district. You have thoughts about the Solicitor General's approach, and then in the course of answering that, do you see differences between your basic submissions and the federal government's submissions? I'm going to ask them that too.
I do, Justice Kavanaugh. I do think the top line response is we like the proposal and we don't. I think we like it insofar as you know from our original briefing and our supplemental briefing that the thing we want most as the state is clarity in this area of the law. And so any remodeling of jingles that brings about that clarity, of course, we're going to like. I think the reason we don't like it, there's a practical reason and a doctrinal reason. I think the practical reason with the proposal is that you're probably going to see a new front of Section 2 litigation over what any new test means and how it plays out on the ground. And so I think the upshot is the courts are going to continue to be inundated with Section 2 cases under this new test, if it exists. So as a practical matter, I don't know that we get much
What's the practical lack of clarity that you see? I guess I would have thought that solves a lot of the concerns that you've identified and that the amicus briefs that support your side have identified so far.
Yes, if I could answer that and then get to the quick doctrinal point.
Yes.
On the practical point, I do think that you start to see hints of this in the Robinson appellant's yellow brief, the supplemental yellow brief, which is there's going to be a lot of disagreement in the lower courts about racial predominance. That is a critical trigger in a lot of this court's cases, and unless there's absolute clarity about how that analytical framework shakes out, then you're still going to see this onslaught of litigation that we see today in the Section 2 context. The doctrinal reason, Justice Kavanaugh, why we're not totally thrilled with the proposals, I think it's just a half solution to the constitutional problem, because at the end of the day, what the government's asking you to do is keep jingles in some form, and as we've laid out in our supplemental briefs, jingles 1, 2, and 3 are expressly built on the sorts of racial stereotypes that the court's cases say are impermissible under the Equal Protection Clause. And so I think that any test, whether it's good or bad as a practical matter, that at the end of the day is asking the government to assign voters to different districts on the basis of their race and is engaged in stereotypes about how members of a race, simply by virtue of their membership in that racial class, think, I think that's a constitutional problem. And so that's why it's not wholly fulfilling.
I think the reason they say we haven't really addressed their proposal before in our jurisprudence, in part because before Rucho, states wouldn't articulate that objective explicitly, and therefore it's an open question. Do you agree with that?
I think as a practical matter, that's probably true, Your Honor. I mean, I think pre-Rucho, states were going to be very hesitant to venture out to say, overtly, like politically, like here's what we're doing. And so that is, I think, a great explanation of why the court's cases have treated the political versus racial divide as it does.
And just on common ground here, because I think it's always important in a case like this where there's disputes to identify what's common ground. Justice Jackson said the goal is equal opportunity for all Americans. I think we all agree on that completely. And the goal, of course, is racial non-discrimination. But at the same time, given history and given Congress's action, the goal is making sure that there have been sufficient remedies for the history of discrimination in the United States, and we've seen that in the school desegregation context, and the college admissions context, and a variety of contexts. And then Ms. Nelson, I think, suggested if there is going to be a temporal limit, she doesn't want one at all, but then I think she said if there's going to be one, it should be identified in advance. And I just want to get your response to that.
Our response to that is simple, Your Honor. Over 3 decades, dating back to Shaw 1 and Miller, the court has always qualified its voting cases with the caveat that racial stereotyping is bad, the 14th Amendment forbids it, and in all events, it can't persist. I think anybody remotely involved in redistricting knows those caveats and has been on notice since the 1990s. And so, as recently as this court's plurality opinion in Schuette and then SFFA, where the court again reproduced that black letter law that racial stereotyping is not permitted under the 14th Amendment, the warning bells have been sounding for decades, and I think that's a long enough notice for anybody involved, Your Honor.
In response to Justice Kagan, Ms. Nelson said that black representatives and justices in Louisiana have primarily, if not exclusively, been elected in minority opportunity districts, and that the results would be terrible. You want to respond to that?
Sure, Your Honor. I mean, I think there's been a lot of sky is falling rhetoric from the other side in this case. And I just want to give you one political reality why I think that's a little overstated, which is remember that in a case, use a state like Louisiana, Republican legislature. If a Republican legislature wants to maximize its political seats, draw a 6-0 map, remember what has to happen with the hundreds of thousands of Democrat voters that currently exist in the majority Democrat districts, District 2 and District 6. They have to go somewhere, and that means that if the legislature wants to take the risk of maximizing, what they're doing is turning safe districts for high-profile political incumbents purple. And that, I think, is a very dangerous political risk. I don't know what our legislature would do if the court rules in our favor, but I'm just saying that's one political reality that makes me pause and say, I don't think the sky is going to fall.
Thank you.
Justice